So contrary to popular belief, the First Amendment does not give you the right to say anything you want. And that should not be too surprising to people. I think we can all think of things we can't say or do. And in fact, the Supreme Court has cut out two large swaths of unprotected speech. Obscenity and incitement. So speech that is obscene and speech that incites.
Right. Now, we'll go into more detail on these in a future show. There's lots of legal tests and, on the one hand, on the other hand, kind of reasoning. But it basically comes down to this. Is the main goal of the speech just to piss people off? And will it probably lead to imminent lawless action? That's incitement.
Gotta be imminent.
Gotta be imminent.
An example of what would be incitement would be if somebody was giving a speech and advocated, and not only advocated, but told people to follow him across the street to attack minorities. So that person we interviewed, Hillary, at the beginning of the show, she was so concerned about the KKK having First Amendment rights. Well, the reason they can give their speeches is because they're not advocating imminent violence. They're just saying whites are better than minorities, which might be an odious thing to say, but it is protected under the First Amendment. The other category of unprotected speech is obscenity. Now, obscenity basically comes down to this. Is the speech just disgusting and gross with no redeeming value whatsoever? If so, it's obscene. But we can't get to that right now. We are going to get right to the constitutional analysis of this crush video law. So Wait, hold on a second. You just said that obscenity, which is unprotected speech, right?
Right.
And is defined by the court as something that is disgusting and gross with no redeeming value whatsoever, right?
Basically, yes.
Well, wouldn't that cover crush videos?
Aha. That's a very good question. And I was hoping to kind of brush past that. Because the answer is maybe. And I don't really like to give maybe answers. But let's just talk about the one specific part of the test for obscenity that's especially relevant here. Now, one of the tests for obscenity is whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. Does that language sound familiar to you, Ben?
From the law.
Exactly, right? So Congress was trying to actually mirror the language of Supreme Court decisions to carve out this exception for artistic, literary, political, etc. value. Now, here's the thing. In the original obscenity test, the question isn't just whether it lacks this value, but whether the work taken as a whole lacks the value. If part of the work might have some artistic value, then it can't be obscene. So in that crush video that we just heard with the grape, for instance, there was kind of echoing and laughter, and it was kind of artistic a little bit.
It was kind of artistic. Yeah, it was.
Until it got kind of weird and gross. So even if it were animals instead of grapes, it still might not be obscene. And it's kind of a judgment call. But the only thing that the Supreme Court has ever said is totally obscene, like a whole category that's obscene, is child pornography. Otherwise, the First Amendment has a pretty broad leeway for that kind of thing. So it's probably not obscene. But I promise you we will talk about obscenity at length in a future show. There's a lot of interesting cases. But we can't talk about it now, because we have to deal with crush videos. You see, Congress has forced our hand. They are trying to create a new category of unprotected speech. Not just incitement, not just obscenity, but animal cruelty. So, the big question now is, how does the Supreme Court decide whether or not to grant this new category of unprotected speech? This is it. It's that time. It's what you've all been waiting for. Can somebody cue the thinking music? It's time for constitutional analysis with Matt and Ben. All right, folks, we've made you wait a while for this, but it was time well spent.
We're about to impart really, really important knowledge here.
It's almost like alchemy what we're about to do.
Alchemy.
We're sitting here with test tubes, beakers. Things are bubbling. Justice is percolating, Ben.
Justice is percolating.
So, when the Supreme Court is faced with a constitutional challenge to a law that allegedly violates First Amendment rights, what is the first thing the court does, Ben?
when reviewing a law that impinges on the freedom of speech, they would subject it to a very, very strict analysis.
Aha, I see what you're doing. Yes, one might say that the scrutiny they're about to apply is very strict.
Meaning it has to be as narrow and as necessary as humanly possible.
Okay, so we're using some actual terms of art.
Why don't you walk through that?
I will walk you through it. Ladies and gentlemen, it's time for the legal soundbite of the day. If the government wants to pass a law restricting certain forms of speech because of its content, the law must be narrowly tailored to achieve a compelling state interest. Now, there are some terms of art there, but it's really not complicated. All you've got to do is close your eyes and imagine Lady Justice. Ah, that great giant statue of a blindfolded woman holding a sword in one hand and scales of justice in the other. On one side of the scale, you've got individual rights, and on the other side, you've got state interests. Now, what most people don't know is that Lady Justice has an enormous thumb. And the more important the individual right, the more likely she is to push down on that side of the scale. Because in a constitutional democracy like ours, Lady Justice really doesn't like to see the government trumping the individual unless the government has a really, really good reason for it. Okay, you can stop picturing Lady Justice now. So in this case, the right that's implicated is freedom of speech, which is pretty much one of the big ones.
That is one of the big ones.
It's a big right. I mean, it's the First Amendment.
It's the one everyone knows. If you asked, name something in the Constitution, that's the one that's coming out.
Yeah, they're not going to say, the government can't quarter soldiers in my house.
Quarter soldiers is my favorite, yeah. You might get bear arms. That might, but depending on where you're at. But you're going to get freedom of speech right away.
Okay, so freedom of speech is on the one hand. On the other hand, we've got the state interest, which in this case is protecting animals from cruelty, right? Animal cruelty.
The question is that a compelling state interest, the prohibition on animal cruelty?
That is the question. So, has the court ever looked at animal cruelty?
I believe they have.
I believe you're right. What was the case, Ben?
I don't know.
Maybe Google knows.
Supreme Court, animal.
By the way, in case you're wondering, this is how a lot of legal research starts. You type something into Google, and you find out what the state of the law is.
Dogfighting is illegal in all 50 states. Cockfighting. And several states have recently enacted laws to prohibit hot dog fighting. I don't even know what that is.
Hot dog fighting?
What's hot dog fighting?
I'm picturing kind of like a jousting event where we're both on horses and we have long hot dogs in either hand.
Hot dog fight. Play. Is dachshunds.
You are not watching a dog fighting video, are you?
I think I am.
Turn that off. No, that's... You can't watch a dog
it's not
fighting
illegal
video.
because no one's selling it. It's free, right?
Oh,
I'm just
my
looking
God.
at the damn thing.
Ben, turn that off. How did you find that so fast?
YouTube.
By the way, in case you're wondering, that also happens a lot during legal research.
Oh, there's an animal sacrifice case that comes up under different parts of the First Amendment.
It turns out that in 1993, the Supreme Court heard a case involving a city ban on ritual animal sacrifice. In that case, which pitted the Church of Lukumi Babaluaye versus the city of Hialeah, Florida, the Supreme Court ruled that it was a violation of the church's constitutional rights to freedom of religion when the city outlawed animal sacrifice.
This is that same question without the religion. And this is... So
let's just be clear on what we've got here. We've got a case in 1993 in which the Supreme Court held that an individual's right to free exercise of religion trumps the government's interest in preventing cruelty to animals. So that would lead one to believe that it is not a compelling interest. But we don't know for sure, because that case had some specific quirks that don't necessarily apply here. The justices there thought that the city kind of had it out for that religious sect, and that they weren't really concerned about cruelty to animals. So it could be different in this specific context.
We don't know what they're going to do. If it's not a compelling interest, the law is unconstitutional, and that's that. If it is a compelling interest and it passes that first part of the test, now the court will determine if it's narrowly tailored to further that interest.
Well, wait. Before we get there, I just have one simple question for you.
Yeah.
How does the Supreme Court decide what is a compelling interest?
This is my thought on this, and it goes back to an old Scalia quote, and it's a Scalia quote in a right to die case, and he says people come before the Supreme Court all the time asking us to make these value judgments, and he's being asked to determine, right, in this case, I think maybe it's an abortion case, when does life begin, right? And he says you'd have a better chance of answering that question by asking 9 random people from a Kansas City phone book. He has no idea, no clue, no idea. And he doesn't, and why would he? So he would say, I don't know what's a compelling interest. I don't have any idea.
These are 9 unelected officials.
Yeah, appointed for life.
For life.
That you need to convince 5.
Right.
5 people out of 350 million. So I don't think you can. I think it's.
But they do.
But they do. They do every day.
All the time. These are angels dancing on the head of a pin kind of question.
Right, blindfolded.
Are the angels blindfolded?
Yeah, I think so. You can't blindfold a pin. A pin does have an eye, though, doesn't it? A needle has an eye.
A sewing needle has an eye. You can blindfold a sewing needle.
That's good to know.
I'm glad we cleared that up.
My name's Alec Davis.
Hi, Alec. What does the First Amendment mean to you?
First Amendment, I suppose it's really important just because it's such a staple of who we are as Americans. It's something that's unique to the extent in which we take advantage of it. It's just unfortunate that some people abuse the right of freedom of speech.
Well, let me ask you a specific hypothetical here. Congress recently passed a law stating that you cannot sell videos that depict animal cruelty. What do you think of that? Should that kind of thing be allowed under the First Amendment?
That's a perfect example, actually, in my opinion, because I think they should be free to do that. However, I think that the fact that they are using First Amendment to justify the fact that they are doing that, I don't necessarily agree with that. I think that they should appreciate it more.
You think that cheapens the First Amendment?
I think it does.